Good afternoon, everyone. This is Sara Khaki with Atlanta Divorce Law Group, and I'm super excited to interview my good friend, Jonathan Page, business law attorney and the founder and owner of InPrime Legal, to discuss how divorce impacts business owners. Jonathan, welcome.
I'm glad to be here.
Thank you. So, Jonathan, let's start from the drone view, first of all. One of the things I've learned from you, and you're so good about drilling this into your clients, and I'm not shy to say that myself and my husband have worked with Jonathan's firm, and I'm feeling like I'm sharing a huge resource of mine here live. So, but you talk a lot about the operating agreement. And so for all business owners, whether they're going through divorce, not going through divorce, contemplating going through divorce, can we talk about how significant the operating agreement can be? And if they haven't already started the divorce process, how there are certain things that they can look at right now to prepare themselves and discuss with their divorce attorneys regarding what the operating agreement requires in the case of a divorce.
Absolutely. So I'm going to just talk about the operating agreement briefly, generally, and then we can kind of dial down into how it deals with divorce. So in a general view, the operating agreement is your most key document that you have in a business. And when I say operating agreement, under a limited liability company, it would be called an operating agreement. If you were a corporation, oftentimes it's called a shareholders agreement. And then there's also a set of bylaws that are required when you're incorporating a corporation and under the Georgia Business Corporation Act. But if we're assuming we're under the Georgia Limited Liability Act, it's called an operating agreement, and it's basically a combination of both your shareholders agreement and your bylaws, all in one document. And it's absolutely critical. First reason it's critical is because you formed a limited liability company, or you formed a corporation because you were trying to separate your business from yourself individually. Right? You wanted to protect your personal assets and other business ventures from the liabilities that might be associated with the particular business that you're talking about. And in order to preserve that independence, you need to memorialize in writing that it is in fact an independent and separate entity. And the way that you do that is through the written operating agreement. That shows a court later, or somebody who's trying to pierce the veil, as they say, under law, or they're trying to crack that protection that you created for your personal assets and be able to say that they can come after the owners personally for the liabilities of the company. Everything that's in the operating agreement shows that it in fact is separate and independent, and that you shouldn't be able to come after those owners personally. With that said, the operating agreement deals with the management structure of the company, how decisions are made, who has control, who has the right to make certain decisions, what is the vote requirements for certain matters. It also deals with the ownership structure. That can get fairly complex. It can be as simple as, you've got membership rights. It can be as complex as there's these various classes of ownership, and each class has different rights and obligations associated with them. There could be a class that you can't even vote. There can be a class where you can vote, those sort of things. It also deals with exit strategies. At some point, owners are going to exit. We're all aware, hopefully, everyone knows we're going to die at some point, right? That's inevitable. And that is an exit. That's the most common exit, right? When you die, you are now exited from the business. And the operating agreement actually deals with that situation. What happens when an owner dies? What happens when they become permanently disabled? So all of those are sort of exit provisions. And then you've got dispute resolution. What happens if the members are disputing? And there's a lot of other key aspects to that operating agreement. So with regards to divorce, where that comes up is in the what's called the exit strategies. And really those exit strategies you've got two components to it. You have your disassociation, and then you've got your buyout. And people get confused about this. So disassociating somebody means that you're stripping them of all of their non-economic rights, their right to vote, the right to have a say in decisions, but you're not getting rid of their economic rights. Just because you remove somebody from the company doesn't mean that they don't have their economic rights. In order to redeem those economic rights, you have to actually purchase their interest, and that's the buyout provisions. And so divorce is often a disassociation trigger where somebody who's going through a divorce, and typically the way the operating agreement will read is it says if there is a voluntary or, if a petition is even filed, once it's filed, whether the divorce actually consummates, whether it happens or not, that then triggers the right of the other owners to disassociate that member. And what the concern is there is, a couple of things. One, the spouse could come in and take the economic rights. The court could order that spouse gets the economic rights of the member spouse and then starts receiving all of those distributions. The spouse could get control and could receive the rights that the member who is there now has. And so by allowing the disassociation, the members can kind of protect, and they can also set a value, because if they're going to buy them out based on that disassociation and trigger the buyout provisions, then whatever values paid at that time is what's going to be part of that marital estate. It sort of establishes this is this member's, share of the business. This is what it's worth. This is what we valued it at. And there could be a big discount there. And, this is all that's going to be part of that marital estate. So that's the reason why they often will include that divorce as a provision within the operating agreement that then allows the other members to disassociate the member who is going through a divorce. And then if they so choose, buy them out of their economic rights in the company.
And so in Georgia, the presumption is that if you are going through a divorce, the marital assets, which includes any business interests that were gained during the time of marriage, is presumptively open for a 50-50 split. And you can then, start making the argument that no, this should be less than that or more than that. So in the case of a partnership where the members are at risk of having an ex-spouse come in and getting some interest of the business, is there a fiduciary duty for the member who is going through divorce to go to their partners and say, my marriage is in trouble, or I think I'm going to have to file? Do they have to do anything as far as just a fiduciary duty to the other members and give them a heads up that a divorce is pending or is about to come along?
So if you're under the Georgia Limited Liability Act, the Georgia Limited Liability Act, with the exception of a few things, puts everything that deals with any sort of obligations of any member, it allows you to write that into that operating agreement. Again, another reason why it's so key, because that's the deal. And so to the extent you have an obligation to let the other members know that you're going through a divorce, that would be dictated by the operating agreement. And if it is something that would trigger a disassociation right, then yes, you would need to tell your other members that there is this thing that happened in my life that gives you the right to disassociate me. So the other thing is when you go through a divorce, it's public. So it's not like you can hide it once you file. Now, whether you need to tell them that your marriage is rocky, no. Until somebody actually goes and files divorce, you don't know that you're going to go through a divorce. I mean, you may think there's a 99% chance that you're going to go through a divorce, but until that petition's filed, you're typically not going to have an obligation to go let your other partners know. But once that petition is filed, and if there is in fact a disassociation right for divorce, then you would need to let them know, because that's material. And it implicates a material provision within the operating agreement. Now, because the operating agreement is the deal you struck, you could draft that operating agreement such that divorce is not a disassociation right. And because you're going through a divorce, doesn't give the other members the right to do anything with regards to your interest. And if that's the case, then you may not have an obligation to let them know, even when the divorce is filed.
How about the type of corporation you form? Could that make a difference on how much, whether you have to share this or you have to go through this?
In my opinion, it's not going to really have much of an impact. An interest in a business is an interest in a business. Under the Georgia Corporation Code or Act, it's a different statutory scheme than the Georgia Limited Liability Act. And so there's some confusion around that, because people will form an LLC. And by forming an LLC, by state law, they are governed by the Georgia Limited Liability Act. They are not governed by the Georgia Business Corporation Code. But then they will go make a deal with the IRS, which is only their deal with the IRS, that they'll be taxed under, say, subchapter S of the Internal Revenue Code, which is an S corporation. So then they go around thinking, well, I'm a corporation because I made the election to be taxed as an S corporation. Well, no, you're not governed by the Georgia Business Corporation Act or code because you made that election with the IRS. That election with the IRS was a deal you made with the IRS. You and the IRS made a deal and said, when in terms of how I report my taxes and how I, pay taxes, I want to be governed under, this regulatory framework that's subchapter S under the Internal Revenue Code. But you're still governed by the Georgia Limited Liability Act. But regardless, whether you have an interest that is a membership interest or you have shares in a corporation, it's still an interest and it's still subject to the marital estate.
Let's think about most business owners in this country are family-owned businesses, mom and pop shops. And a lot of these businesses are run on the back of a family, whether it's dad running the business, mom at home with the kids, or both husband and wife in the business together. Now, the business might be under the husband's name or the wife's name, but the other spouse is helping in some shape or form. What becomes very difficult on our end, Jonathan, from the divorce attorney side, is not being able to clearly see how much a family or a business owner took home from their business, because a lot of these business owners aren't paying themselves. So when we come to do the marital balance sheet to understand, we start treating the household as a budget. What's coming in, what's going out, and the inconsistency of not having a consistent paycheck really makes things more fuzzy, can cause a divorce process to go on longer, cause a lot of gray areas that causes a lot of fighting, and it really drives up your attorney's fees as well, rather than just having a paycheck and we're clear on that. Mm-hmm. Can you speak from the advice you give your clients on the importance of business owners paying themselves a steady paycheck from your perspective?
Absolutely. Yeah, we always recommend to our clients that they put themselves on payroll, and if they have a spouse that's providing any service to the company, that spouse is on payroll, and it should be competitive salaries. When you get into it with, when you're obviously, if you're taking distributions from the company, which is not wages, right? It's distributions to an owner of the company. It's taxed differently than if you're paying yourself wages. If you're an S corporation, for example, and you have a salary, but you're also the owner, that salary is going to be subject to FICA, and you're going to be paying, Social Security and Medicare. And, sometimes tax accountants will make the recommendation, if you could pay yourself $1 in wages, pay yourself $1 in wages, because then you're only paying Social Security and Medicare on that dollar. And then the rest of it you're taking through distributions, which would not be subject to Social Security or Medicare. Again, we're talking specifically in a situation where you've elected to be taxed as an S corporation. And so sometimes you'll get that kind of advice, but I think it's psychologically, you need to have some guaranteed compensation in there. And by putting yourself on payroll, or, if it's just a general partnership, making sure that you have guaranteed compensation is really key. And it also shows, I think business owners are doing themselves a disservice when they don't do that, because if they weren't doing the job, somebody would have to. Right. And they're not really showing on their profit and loss statements what that job's worth. And if you're really truly trying to scale up a business, typically the objective of the business owners is to be able to exit themselves from the operations of the business, right? We all want to be able to have a business that can operate without us. So we're truly the owner, right? We don't, we didn't create a business to get a job. And so until you're willing to really quantify and put a dollar amount on what your time is worth for the services that you're providing and the services that your spouse is providing, I think psychologically you're thinking that you're doing better than you are, because you've got some more profit there because you weren't paying yourself a true salary. And I would imagine in the divorce context, it also creates a course of conduct. So, at the moment that divorce is filed, you can look back in time and say, well, my spouse was paid $80,000 a year for the last 4 years. And I was paid, $400,000 a year for the last 4 years. And it just kind of shows whether whether the spouse is the female that's getting 400,000 and the guy is getting 80,000. However that works out, it just shows this is what those services were worth, and there's a course of conduct that establishes what the value of those services were, within the marketplace. And I think that's important. There's a client of ours that, they've got their business now is doing close to 10 million. And when they started with us, they were doing under $1 million. And I really encouraged them to start paying. There was 2 partners started paying each other $10,000 a month. And they're like, I don't know that I can do that. It's we're gonna have a loss. And I'm like, if you start paying yourself $10,000 a month, you will make more money.
Mm-hmm.
And they just kind of looked at me, and they did it. And because they had that financial commitment every month, they had $10,000 a month out of the business. They ended up doing things, and it created cause and effect that caused them to generate more money because they had to cover that $10,000 a month. But before they did that, they were always thinking, oh, well, we could just not take a distribution this month. We could just not pay ourselves this month.
They were tolerating the business to, work them versus the other way around.
Yeah.
And also you make a really good point about not paying yourself doesn't really show the true P&L of the business, because if you are, whether you're holding the hat of the CEO or the marketing person, or in our case, one of the lawyers, somebody else would have had to be paid to do that job. And now you're making the business look more profitable than it truly is, which then in the divorce, you're showing a more profitable, from the business owner's standpoint, you're showing more profitable numbers that need to be split up and considered versus if you were paying yourself and then you had a more true P&L.
Mm-hmm.
The other thing that I think is also important is when you have a spouse that is not necessarily the owner, but they are helping you out in the business and you're not paying them, historically, it looks more like they're contributing as an owner versus another salaried employee, which then later on, they could use that as an argument of, I contributed here. I put in sweat equity into this business just as he did or she did, the owner of the business. So I should be treated as a co-owner in this when we're looking at it from the divorce standpoint versus saying, he did a job. He was my bookkeeper. I paid him just like I would pay any other bookkeeper. There was no real sweat equity put in here that I should now repay for. Do you see that argument?
Yeah, absolutely. I mean, do you want the court to determine what those services are valued at, or do you want to be able to show through course of conduct, this is what you both agreed? Because, in the divorce context, especially if it's disputed, everyone's going to position for the best position for them.
Right.
And it could be that your spouse a year ago would have agreed with you that those services were worth $40,000 a year. But now that y'all never made that agreement and she did it through sweat equity and you're in front of the judge, you're telling the judge, it's worth $500,000 a year. It's worth, he makes $500,000 or she makes $500,000. And, my services were just as valuable. So yeah, I think, having that memorialized and in writing and a course of conduct that shows that would be important.
Let's talk about one of my favorite subjects in business, which is how do you evaluate a business? And this becomes pretty challenging when you talk about family-owned businesses that are really, again, on the backs of people, right? We're not talking about an Apple or a Walmart. We're talking about a mom and pop cleaners, a mom and pop landscaping business, or a art shop. So in a situation where the divorce comes up, now we have the option of the spouse sells their interest in the business to the other spouse if they were co-owners, or they just sell the business altogether. How do you evaluate what that interest, the business interest actually is?
Mm-hmm. So there's kind of 2 ways to view this. There is how the owners agree that it should be valued, and that would be in that operating agreement. Again, another reason why that's so key. And then there's how a third party who's coming to acquire the business would value it, right? Through comparables and, depending on the industry and the type of business and what growth stage it's at, they're going to be using various valuation methods to do that. And an acquirer, third party who's coming in to acquire a business, doesn't really care how the owners agreed it should be valued, because at the end of the day, it's what a willing buyer's, and a willing seller's going to do. But so it's kind of two approaches to valuation. If you're talking about the owners, there's several flavors for how they'll do it. One, which is the most flexible, is fair market value, which is similar to what that third party would be looking at. And in that case, they probably would be getting a third-party business valuation expert to come in and do a valuation based on comparables in their industry, the growth stage. That would determine the method. A common method would be EBITDA, so earnings before interest, taxes, depreciation, and amortization. And they would be doing some multiple of EBITDA, but some industries might be doing a multiple of the actual revenue. If it's, for example, there was a big company here in Atlanta that was a precursor to Salesforce. This was like 10 or 12 years ago. They made no money. They ended up selling for $100 million. So if they had done it as a multiple of EBITDA, it would have been a zero valuation, because literally they lost money. Why were they able to get $100 million purchase price? Because they understood it's a SaaS product. The acquirer understood that they were buying something that they had customers. They were buying the customers, and they weren't buying the investment that was being made and why they were losing money year after year. So they were using a very different valuation method for that business. But if it's if it's a business that has been in business for 20 years, it's got a pretty established EBITDA. They're not really making investments into different areas. They're not developing big SaaS products that would eat up a lot of cash. EBITDA may be a better model for valuing that business. It could be a manufacturer who manufactures medical devices, and so they're probably going to be doing some sort of multiple of EBITDA. So that would be all kind of fair market value. It's going to depend on the industry, the growth stage, et cetera. The owners then could do some alternative things. They might do it. They might set the valuation biannual agreement. So every year they meet and they set a value per unit or per share. And, and it's a very easy, once they set that value, you know how many units you own or shares you own, and you do the multiplication. They could do it based on book value, which is basically the value based on your financial books and doesn't typically include goodwill. There could be adjusted book value, so you could have some specific formula for how you determine the value that the owners agreed on. This is the formula we're going to use. And then there's a variety of other ways that the owners may agree that it should be valued. There may be discounts. If it's a key employee and it's a key member and they're being disassociated, their service to the company may have been so critical that if they base the value the day before they were disassociated, they would argue that the value is going to be decreased substantially the day after. Mm-hmm. And so they will incorporate into the operating agreement that in that situation, they actually get to do some sort of reduction on the buyout price. Maybe it's a 30% reduction from fair market value in consideration of the fact that that particular owner is no longer going to be involved in the business and can no longer contribute to the business. So there's all sorts of things that are considered when the owners do it. In the divorce context, what really they're going to be looking at is that operating agreement, right? Because the interest that the spouse is potentially coming into, that's going to be part of that marital estate, that interest is dealt with through the operating agreement and through the buyout provisions that they have in that operating agreement. And so that's what I think the court would likely be looking at, because that's the agreement the owners made before divorce was ever contemplated.
The families that I really think about too, that I feel like fall through the cracks a little bit of all this is, for instance, the husband and wife, that the husband had a landscaping business. It was all based on a list of clients that no matter, really, what's the value in his equipment, right? Not a lot. And it's a list that's going to follow him no matter where he goes. She may have not really been able to participate in the business. She's been at home taking care of the family, taking care of the kids, while he's been running this landscaping business. And then when it comes time to evaluate this business, the business is his cell phone. The name's on his cell phone that text message him and say, we need the grass cut. We have a lot of clients like that. And I mean, is there anything that any advice you would have for that kind of a family where they're dependent on that income, but that business income, it's not really running as a business, it's really running as a person in the family giving services based on a goodwill of a list that they've created on their own name and their own back of work?
Mm-hmm. So I think if the spouse who, if one spouse in that situation, likely the business needs to stay with one spouse, right? And it's probably going to be the spouse who has that owns that contact list. And so they're going to ultimately keep the business. And then there's going to be some valuation or, of the interest of the business to figure out what the wife would be paid for her share of that. But there are things that could have been done in the operating agreement. One is that members are often put under non-competes. Under the Georgia Trade Secrets Act, a customer list is presumptively considered a trade secret. And so what that means is, if he or she is not remaining with the company and they have the contact list, technically they really can't go and leverage that contact list if they're no longer part of the company, because that contact list belongs to the company. It's the company's, asset. And so those things can be put into the operating agreement, and you can definitely have a non-compete in there. It's very typical that owners who are exited cannot compete against the business within a certain geographic radius. They cannot take any customer list with them. There's all sorts of things that you can do to make sure that, you protect that customer list, because customers are the key asset of any business, right? No customer, right. You don't have a business. I mean, that's how you generate the revenue for the business. So, it's really, really important that you protect that list.
So let's talk about the third choice that we have in this situation where husband and wife own a business together. We talked about them selling the business altogether or selling their interest to each other. The third option being that sorry, I'm drawing a blank here, but the third option being that they actually stay co-owners together. So what advice do you have if they choose to stay in co-ownership together, but they're getting divorced? I know other than they probably need to do some family therapy to get through that, but neither you and I are therapists. But from a business standpoint, as a business lawyer, what advice do you give to partners that come to you and say, we are getting divorced but wish to stay in business together?
So I have not actually dealt with that specific situation where a divorcing couple wants to stay in business together, but it's definitely possible, and they could do that. And I'm certain a court would be fine with that if they both said that that's what they wanted. The general advice I give to anyone that's getting into business with anybody, and I think it would apply to a couple that's getting a divorced, is this is what I tell them. I say there's 4 critical things if you're going to be successful as a business in a business partnership. The first is that you have to have a common vision. If one of you wants to scale the company to 50 million and the other one just wants a lifestyle business and just wants to continue receiving whatever distributions you're receiving to date, you're not going to be successful together. Whether you're spouses or whether you're not, whether you were married at one point and now divorced, if the 2 owners have a different vision for where the company's going, you're not going to be able to successfully manage that business. The second thing is that you have to have a common mission, right? And the mission's a little bit different. Why are you in business? How are you improving your community? How are you improving your customers' lives? That's really what the mission of the business is. And you both have to be passionate about that mission. And as owners, if you're not both passionate about that mission, it's not going to be successful, because one of the owners is going to be willing to compromise or, devalue what it is that they're trying to do. And it's going to make it difficult for you guys to own this business together. The third thing that's absolutely critical is that you both have to have the same values. Mm-hmm. And if core values, and if one of the owners, has a very different value about business and about, people, maybe the owner doesn't really, value people as much as they value, some other thing. But one of the owners really values people, then, you're just not going to be successful together. And each business has different values. Not every business, almost no business has the same values as another business. They all have their own kind of core values, and the owners really have to share those core values if they're going to be successful. And the fourth thing that I tell business owners, if they want to be absolutely successful together, is they have to be different in everything else. So they have the same vision, they've got the same mission, they're passionate about the same mission in life, they've got the same core values, and then everything else they're different. Because if they're bringing the same talents to the business, that's really not going to work either. You're just going to be stepping on each other's toes. What's really best is if you're different in everything else. So I'm in business with my wife, and it's awesome. We have the same vision. We're passionate about the same things. We value the same things, and we're different in every single thing. And that really, I think, is what makes us successful.
And you guys do work like a fantastic team together. And I've never actually had heard that advice before of different in every other way. That's so true. And now that you say it, it's like, that's so obvious, but had never heard anybody articulate that. So that's fantastic. Can you give a little advice on how you and Mariana make it work so well as co-owners? And I mean, you have 5 beautiful children. I've seen your kids. They're healthy, bright, good kids. And my husband and I are clients of InPrime, and we know what kind of a quality of service you deliver. A lot of people just want to know, how do you do all of that together and not tear each other apart?
So I could speak on this for an hour. There's a lot there to talk about. But what I would tell you is, so when people get married, the way they are, so in general, right? If you're somebody who's trying to achieve something different in your life, you're trying to achieve a better lifestyle. You want to live in a nicer house. There's things of beauty that you want to experience. You want to be able to afford to go on certain trips, so you can experience the world in a certain way. But you're not there today, right? Then in order to be able to achieve those new things in life, you have to change. Because if you continue to operate the way you operate today, you're going to continue to get the results that you get today. And so at some point, somebody who's trying to achieve bigger things in life, they're trying to enlarge their life or enhance their life in some way, come to the realization that they're going to have to change the way that they think and the way that they look at life in order to get different results in life, right? And so when you first get married, you're at a certain place in your life, and you've got a certain mindset, and you have a certain point of view. And if you're there and if you're looking to achieve 10 years into the marriage, your mindset and your point of view is going to be drastically different, because you've been constantly working to change the way that you think and your point of view of the world so that you can have a better life. If your spouse isn't making those same changes, then what I've seen is you start growing in different directions. And I've seen this with my clients. A lot of our clients, unfortunately, because I feel like a business owner is one of the greatest places for growth, running a business, because it really challenges you to grow and do things differently in order to achieve the results. It's very achievement oriented when you're owning a business. You go to build a business because you are trying to create something greater in life. And I just seen too many times where one of the spouses ends up growing significantly in a direction and the other spouse doesn't, and then that's what ultimately causes that divorce later, because they're not the same as when they got married. So with my wife, we chose to grow together, and one of the great things about owning a business together is we both became advocates for the vision in our lives. We both are advocates for our mission. We're both working on this together. And so we have a business coach. Our business coach meets with us. It's the same business coach. We use the same business coach, meets with us individually, meets with us together. We are in constant conversations about what it is we're trying to achieve in life, and, the income we're trying to achieve, and the people we're trying to serve, and how we're going to serve those people, and how we're going to improve our community. These are discussions that we regularly have. And I think it makes us stronger. And I'm not saying it makes it easier, right? It's hard to run a business with your spouse, right? But it's worth it, because what you're working on together, and the conversations and the failures you have together and the successes you have together only make you so much stronger as a couple. And so that's just been my experience. I also think if you've got two spouses who own different companies, but they're still, going to, workshops together, they're talking about each other's businesses. I think that can be true of those spouses as well. That you don't necessarily have to be working in the same business, or even if you've got a spouse who isn't going to work in your business, but is participating in those things. You and I have been at events where, one of the spouses is the owner, the other spouse isn't involved in the business, but he or she is there and is getting the same coaching and is listening to the same thing. And they're making sure that they're both, they're both willing to change and make the same changes in order to achieve whatever there is to achieve. And I think it's just black and white. I hate to say it, that if you want different results in life, you are going to have to change. And you cannot continue thinking the same way or having the same perspective and expecting something different in your life. And so if you're trying to enhance and improve, you're gonna have to change. And my advice to those who are married is don't make sure that those changes, you're doing them with your spouse, whether they're working in the business with you, whether they're not working in the business with you, whether they've got their own business, that you as a couple are choosing to make those changes together and to be part of that journey together. And I think that's what keeps the marriage strong.
Jonathan, you should have seminars on this. I could listen to you talk about this forever. It's so brilliant and so true. And you're absolutely right. I think at the end of the day, the business, whether it's a joint business or separate businesses, it forces a joint vision. And that vision has to bleed into the family unit and become a vision that the whole family sort of campaigns behind. And that will, if you leverage it, if you let it become your tailwind instead of your headwind, it can actually help you grow as a couple rather than fall apart, because it has the potential to do both, right? Because the business will force you to create a vision and look inward and say, what do I need to change? How do I want to grow? And it will either expose a weak marriage that can't sustain that change and sustain that growth, or it will strengthen the marriage the way it has for you and Mariana to get on board together and really become self-aware and be able to see each other and challenge each other, as I know Mariana does for you, and become better. Jonathan, for people that like to find you and find InPrime and get in touch with your team, could you tell us where they should look you up or look up InPrime Legal?
Sure. It's InPrimeLegal.com. N as in Nancy, P as in Paul, R as in Roger, I, M as in Mom, E as in Edward, legal.com. And you can get our team, contact us, all of our information's there.
And I'll make sure we'll add that to our comment section. Jonathan, thank you so much for this brilliant time, as always. If anybody needs any business law advice or contemplating starting a business or needs an operating agreement, don't feel shameful or guilty if you don't have one. Just after watching this is the point of it, is to bring some awareness to it and get everybody the attention that their business needs. Reach out to Jonathan's page. I could not give them any higher recommendation. Thank you again, Jonathan.
You're welcome, Sarah. Thank you for having me.
Absolutely.